Hello everyone, I'm Ratrika Bhaumik and I welcome you all to another episode of Courts Today on LiveLaw, where we update you about all the important legal developments that took place across the country today. We will begin with developments from the Supreme Court and then cover High Courts and other subordinate courts. If you like our content, please do not forget to like and subscribe to our YouTube channel. Let's begin. The Supreme Court today continued hearing the petitions challenging the Karnataka High Court's judgment which upheld the ban on wearing of hijab by Muslim students in educational institutions. Today was the 7th day of hearing by a bench comprising Justices Hemant Gupta and Sudhanshu Dhulia. Senior Advocate Dushyant Dave, appearing for the petitioners, made elaborate submissions on the religious and cultural diversity of India, Constituent Assembly debates and the protection of religious rights under Article 25 of the Constitution. Furthermore, Senior Advocate Dushyant Dave, while emphasizing on a Muslim woman's right to wear a hijab if she thinks it is essential to her faith, argued, and I quote here, "If a Muslim woman thinks that wearing of hijab is conducive for her religion, no authority, no court can say otherwise." The Supreme Court today referred to a 5-judge bench the issue relating to hearing the accused before imposing the death penalty on him. A bench comprising Chief Justice of India, UU Lalit, Justices S. Ravinder Bhatt and Sudhanshu Dhulia noted that there were conflicting judgments regarding the grant of hearing to an accused before imposing the death sentence on him. The bench further noted that in the Bachchan Singh case, the court had mandated separate hearing of the accused before imposing the death sentence on him as per the recommendations of the 48th Law Commission of India. It was further noted that in all cases where the death penalty is a choice, it is necessary to place mitigating circumstances on record. However, the mitigating circumstances relating to death sentence can be placed on record only after the conviction. A Constitution bench of the Supreme Court today ruled that a judgment delivered by a larger bench will prevail irrespective of the number of judges constituting the majority. To illustrate, the judgment of a 7-judge bench delivered with a 4:3 majority will prevail over a unanimous 5-judge bench. A 5-judge bench comprising Justices Indira Banerjee, Hemant Gupta, Surya Kant, M.M. Sundaresh and Sudhanshu Dhulia gave this ruling while answering the second issue in the case titled Trimurti Fragrances Limited versus Government of NCT of Delhi. The bench pointed out that under Article 145 Clause 5, the congruence of the majority judges is viewed as judgment of the court as per the Constitution. The Supreme Court today refused to entertain a petition seeking investigation into the murder of Advocate Tika Lal Taplu in Kashmir Valley in 1989 by militants. The petition also sought rehabilitation of family members and restoration of their properties in the Kashmir Valley and investigation and prosecution of people involved in the murder. The writ petition was filed by Ashutosh Taplu, the son of late Advocate Tika Lal Taplu, seeking protection, rehabilitation of the family members and also investigation into the persons who were involved in the killing of the father of the petitioner, who was a Kashmiri Pandit. The bench comprising Justice B.R. Gavai and Justice C.T. Ravikumar refused to hear the matter on the ground that another matter on similar grounds was also not entertained by the Supreme Court a while back. The Supreme Court bench comprising Chief Justice of India, UU Lalit, Justices S. Ravinder Bhatt and Ajay Rastogi today heard the petition filed by the Enforcement Directorate seeking a plea for transfer of investigation in the Nagrik Apurti Nigam scam case, which relates to corruption in the public distribution system in Chhattisgarh. The bench directed the parties to place material on which they wish to rely in sealed covers. The matter is now listed for 26 September hearing at 3 p.m. The court further directed the parties to submit their written submissions on the maintenance of the petitions. The Supreme Court has kept in abeyance for a week the order of the central government dismissing from service of the Gujarat cadre IPS officer Satish Chandra Verma, who assisted the CBI in the investigation in the Ishra Jahan encounter case. A bench comprising Justices K.M. Joseph and Rishikesh Roy directed that in the meantime it is for Verma to take appropriate steps for amending the writ petition pending before the Delhi High Court to lodge a challenge to the order of dismissal. It is for the High Court to consider the question as to whether order of stay of implementation of order passed by disciplinary authorities to be continued beyond a period of 1 week, the bench added further. The Supreme Court today dismissed a petition challenging the Madras High Court's order of quashing defamation proceedings against AIDMK leader K. Palaniswamy and former party leader O. Paneerselvam. The plea was filed by V.A. Pugazendi, former spokesperson of the AIDMK party, who had filed a defamation case against Palaniswamy and O. Paneerselvam after he was expelled from the party. The matter was heard by a bench comprising the Chief Justice of India, U.U. Lalit, and Justices Ravinder Bhatt and Ajay Rastogi. The Kerala High Court today dismissed the appeals challenging a special court's order cancelling the bail granted to 11 accused persons in the case of lynching of a tribal youth in February 2018. The High Court confirmed the order cancelling bail of 11 of the accused persons by the Manargarh Special Court under the SC/ST Prevention of Atrocities Act. The bail granted to one of the accused was, however, upheld. The Karnataka High Court today directed the Bruhat Bangalore Mahanagara Palike to fill up and repair 221 potholes on major roads as identified by the corporation within 10 days. A division bench of acting Chief Justice Alok Aradhe and Justice S. Vishwajit Shetty gave the direction while hearing a petition filed in the year 2015 by Vijayan Menon praying for directions for filling up of potholes on major roads in the city and for removing encroachments on stormwater drains and the drainage system. The Punjab and Haryana High Court has directed the DGP of Punjab to file an affidavit specifying what steps have been taken to ensure that the religion of the accused victim and witnesses are not mentioned in the FIR. The bench of Justice Jas Gurpreet Singh Puri was essentially dealing with the bail plea moved by an NDPS accused when it noted that in the vernacular of the FIR, the expression Sardar had been used. Further, the court took into account the orders passed by the Director General of Police Punjab in March this year directing the police department to ensure that the religion of the person is not mentioned in the FIR. In an interesting case, a 56-year-old man suffering from a cardiac problem has approached the Delhi High Court praying that his family be prevented from performing the last rites after his death. The Delhi resident instead wants his body to be handed over to a man who he treats as a son, claiming that the person looked after him in his bedridden days. The plea filed by Kunj Bihari Bansal challenges clause 7.1 of the SOP for mortuary framed by the Delhi government, which states that the dead body can only be given to relatives. In his plea, Bansal has alleged that his wife never allowed him to participate in the upbringing of their daughter and that the acrimony between them crossed all limits when he was not even invited to the daughter's wedding. The High Court has posted the matter for hearing on October 14th. Thank you. Keep watching Courts Today on LiveLaw for more such updates. See you tomorrow.